Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Ames v. Ohio Department of Youth Services. In this case, the court considered this issue. Does a plaintiff who belongs to a majority group need to demonstrate background circumstances suggesting that the defendant is the unusual employer who discriminates against the majority in order to establish a prima facie case of discrimination under Title VII of the Civil Rights Act of 1964? The case was decided on June 5, 2025. The Supreme Court held that in a unanimous decision on June 5, 2025, the U.S. Supreme Court ruled in Ames v. Ohio Department of Youth Services, holding that Title VII of the Civil Rights Act of 1964 prohibits employment discrimination based on sexual orientation without imposing a heightened evidentiary standard for plaintiffs from majority groups. The court reversed the Sixth Circuit's decision, which had required Marley Ames, a heterosexual woman, to demonstrate background circumstances suggesting that her employer discriminated against the majority group. Justice Ketanji Brown Jackson, writing for the court, emphasized that Title VII's protections apply equally to all individuals, regardless of group membership. The ruling allows Ames's discrimination claim to proceed in lower courts. This decision clarifies that plaintiffs alleging discrimination under Title VII need not meet additional burdens based on their majority status, thereby potentially broadening the scope for future employment discrimination claims. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Jackson delivered the opinion of the court. Title VII prohibits employers from discriminating against employees on the basis of race, color, religion, sex, or national origin. Under our Title VII precedents, a plaintiff may make out a prima facie case of disparate treatment by showing that she applied for an available position for which she was qualified, but was rejected under circumstances which give rise to an inference of unlawful discrimination. The question in this case is whether, to satisfy that prima facie burden, a plaintiff who is a member of a majority group must also show background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority. We hold that this additional background circumstances requirement is not consistent with Title VII's text or our case law construing the statute. Accordingly, we vacate the judgment below and remand for application of the proper prima facie standard. The Ohio Department of Youth Services operates the state's juvenile correctional system. In 2004, the agency hired petitioner Marley Ames, a heterosexual woman, to serve as an executive secretary. Ames was eventually promoted to program administrator and, in 2019, applied for a newly created management position in the agency's Office of Quality and Improvement. Although the agency interviewed her for the position, it ultimately hired a different candidate, a lesbian woman, to fill the role. A few days after Ames interviewed for the management position, her supervisors removed her from her role as program administrator. She accepted a demotion to the secretarial role she had held when she first joined the agency, a move that resulted in a significant pay cut. The agency then hired a gay man to fill the vacant program administrator position. Ames subsequently filed this lawsuit against the agency under Title VII, alleging that she was denied the management promotion and demoted because of her sexual orientation. The district court granted summary judgment to the agency. The court analyzed Ames's claims under McDonnell Douglas Corporation v. Green, which establishes the traditional framework for evaluating disparate treatment claims that rest on circumstantial evidence. At the first step of that framework, the plaintiff must make a prima facie showing that the defendant acted with a discriminatory motive. Relying on circuit precedent, the district court concluded that Ames had failed to make that showing because she had not presented evidence of background circumstances suggesting that the agency was the rare employer who discriminates against members of a majority group. Without that evidence, the court held, plaintiffs who are members of majority groups, including heterosexual plaintiffs, like Ames, could not discharge their evidentiary burden at the first step of the McDonnell Douglas inquiry. The Sixth Circuit affirmed. Like the district court, the Sixth Circuit held that Ames had failed to meet her prima facie burden because she had not shown background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority. The court reasoned that Ames, as a straight woman, was required to make this showing in addition to the usual ones for establishing a prima facie case, and it explained that plaintiffs can typically satisfy this burden, where applicable, by presenting evidence that a member of the relevant minority group, here, gay people, made the employment decision at issue, or with statistical evidence showing a pattern of discrimination against members of the majority group. The panel concluded that the agency was entitled to summary judgment because Ames had failed to present either type of evidence. Judge Kethledge concurred in the court's decision but wrote separately to express his disagreement with the background circumstances rule. In his view, the requirement was not only unworkable, in that it required an assessment of evidence presented by different plaintiffs under different standards, but also diverged substantially from Title VII's text. The Sixth Circuit's decision reinforced a circuit split as to whether majority group plaintiffs are subject to a different evidentiary burden than minority group plaintiffs at McDonnell-Douglas's first step. We granted certiorari to resolve that split. Title VII's disparate treatment provision bars employers from intentionally discriminating against their employees on the basis of race, color, religion, sex, or national origin. In McDonnell-Douglas, this court laid out a three-step burden-shifting framework for evaluating claims arising under that provision. The McDonnell-Douglas framework aims to bring the litigants and the court expeditiously and fairly to the ultimate question in a disparate treatment case, namely, whether the defendant intentionally discriminated against the plaintiff. At the first step of the familiar three-step inquiry, the plaintiff bears the initial burden of establishing a prima facie case by producing enough evidence to support an inference of discriminatory motive. If the plaintiff clears that hurdle, the burden then shifts to the employer to articulate some legitimate, non-discriminatory reason for the employee's rejection. Finally, if the employer articulates such a justification, the plaintiff must then have a fair opportunity to show that the stated justification was in fact pretext for discrimination. A plaintiff may succeed under the McDonnell-Douglas framework either directly by persuading the court that a discriminatory reason more likely motivated the employer, or indirectly by showing that the employer's proffered explanation is unworthy of credence. For most plaintiffs, the first step of the McDonnell-Douglas framework, the prima facie burden, is not onerous. A plaintiff may satisfy it simply by presenting evidence that she applied for an available position for which she was qualified, but was rejected under circumstances which give rise to an inference of unlawful discrimination. But, under Sixth Circuit precedent, plaintiffs who are members of a majority group bear an additional burden at Step 1. They must also establish background circumstances to support the suspicion that the defendant is that unusual employer who discriminates against the majority. As outlined below, the Sixth Circuit's background circumstances rule cannot be squared with the text of Title VII or our long-standing precedents. And nothing Ohio has said, in its brief or at oral argument, persuades us otherwise. As a textual matter, Title VII's disparate treatment provision draws no distinctions between majority group plaintiffs and minority group plaintiffs. Rather, the provision makes it unlawful to fail or refuse to hire or to discharge any individual, or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment, because of such individual's race, color, religion, sex, or national origin. The law's focus on individuals rather than groups is anything but academic. By establishing the same protections for every individual, without regard to that individual's membership in a minority or majority group, Congress left no room for courts to impose special requirements on majority group plaintiffs alone. Our precedents reinforce that understanding of the statute. In Griggs v. Duke Power Company, we said that discriminatory preference for any group, minority or majority, is precisely and only what Congress has proscribed in Title VII. We made the same point even more explicitly in McDonald v. Santa Fe Trail Transportation Company, a few years later. The employer in that case had argued that certain forms of discrimination against white employees fell outside the reach of Title VII. But we rejected that argument, holding that Title VII prohibited racial discrimination against the white petitioners in that case upon the same standards as would be applicable were they Negroes. Our case law thus makes clear that the standard for proving disparate treatment under Title VII does not vary based on whether or not the plaintiff is a member of a majority group. Accord, Bostock v. Clayton County. This statute works to protect individuals of both sexes from discrimination, and does so equally. The background circumstances rule flouts that basic principle. The background circumstances rule also ignores our instruction to avoid inflexible applications of McDonnell-Douglas's first prong. This court has repeatedly explained that the precise requirements of a prima facie case can vary depending on the context and were never intended to be rigid, mechanized, or ritualistic. In McDonnell-Douglas itself, we observed that the facts necessarily will vary in Title VII cases, and that the prima facie proof required can therefore differ from case to case. The background circumstances rule disregards this admonition by uniformly subjecting all majority group plaintiffs to the same, highly specific evidentiary standard in every case. As the Sixth Circuit observed, the rule effectively requires majority group plaintiffs, and only majority group plaintiffs, to produce certain types of evidence, such as statistical proof or information about the relevant decision-maker's protected traits, that would not otherwise be required to make out a prima facie case. This court has long rejected such inflexible formulations of the prima facie standard in disparate treatment cases. We do so again today. Ohio barely contests any of the above. At oral argument, the state repeatedly acknowledged that Title VII's disparate treatment provision imposes the same prima facie burden on majority group plaintiffs that it imposes on minority group plaintiffs. Its brief likewise offers no justification for imposing a heightened evidentiary standard on majority group plaintiffs. Instead, Ohio tries to attack the premise of the question presented by arguing that the background circumstances rule does not operate to subject majority group plaintiffs to a heightened evidentiary standard at all. Under Ohio's view, the background circumstances requirement is not an additional prima facie element, but, rather, just another way of asking whether the circumstances surrounding an employment decision, if otherwise unexplained, suggest that the decision was because of a protected characteristic. This contention is directly at odds with the Court of Appeals' description of the background circumstances rule and its application of that requirement in this case. The Court of Appeals explicitly held that Ames is heterosexual, which means she must make a showing in addition to the usual ones for establishing a prima facie case, and the ensuing passage of the Court's opinion confirmed that a higher evidentiary standard was being imposed on Ames because of her sexual orientation. The Court stated, "Whether Ames made the necessary showing of background circumstances is the principal issue here because otherwise Ames' prima facie case was easy to make." The Court then recounted how Ames was qualified, had been denied a promotion in favor of a gay candidate, and was later demoted in favor of another gay candidate, evidence that would ordinarily satisfy her prima facie burden, before it specifically faulted Ames for failing to make the requisite showing of background circumstances. In short, the Sixth Circuit expressly based its holding affirming summary judgment in favor of the agency on Ames's failure to satisfy a heightened evidentiary standard. Ohio's attempt to recast the background circumstances rule as an application of the ordinary prima facie standard thus misses the mark by a mile. Ohio also urges this court to affirm the judgment below on alternative grounds, arguing that Ames's Title VII claims would fail even absent the background circumstances rule. But those alternative arguments would require us to resolve issues that the Court of Appeals did not address in the first instance and that fall beyond the scope of the question presented. We granted review to consider the validity of the background circumstances rule, and we reject that rule for the reasons set forth above. We leave it to the courts below to address any of Ohio's remaining arguments on remand. The Sixth Circuit has implemented a rule that requires certain Title VII plaintiffs, those who are members of majority groups, to satisfy a heightened evidentiary standard in order to carry their burden under the first step of the McDonnell-Douglas framework. We conclude that Title VII does not impose such a heightened standard on majority group plaintiffs. Therefore, the judgment below is vacated, and the case is remanded for application of the proper prima facie standard. It is so ordered. Justice Thomas, with whom Justice Gorsuch joins, concurring. I join the Court's opinion in full. I write separately to highlight the problems that arise when judges create textual legal rules and frameworks. Judge-made doctrines have a tendency to distort the underlying statutory text, impose unnecessary burdens on litigants, and cause confusion for courts. The background circumstances rule, correctly rejected by the Court today, is one example of this phenomenon. And, the decision below involves another example. The Sixth Circuit analyzed Ames's Title VII claim under the three-step framework developed by this court in McDonnell-Douglas Corporation v. Green. As with the background circumstances rule, the McDonnell-Douglas framework lacks any basis in the text of Title VII and has proved difficult for courts to apply. In a case where the parties ask us to do so, I would be willing to consider whether the McDonnell-Douglas framework is a workable and useful evidentiary tool. The Sixth Circuit's background circumstances rule imposes a heightened burden on Title VII plaintiffs who belong to so-called majority groups. The rule requires a majority group plaintiff to prove, in addition to the standard elements of a Title VII claim, that background circumstances support the suspicion that the defendant is that unusual employer who discriminates against the majority. This additional requirement is a paradigmatic example of how judge-made doctrines can distort the underlying statutory text. As the Court's opinion explains, the background circumstances rule lacks any basis in the text of Title VII. Title VII bars employment discrimination against any individual because of such individual's race, color, religion, sex, or national origin. Thus, to state the obvious, the statute bars discrimination against any individual on the grounds specified therein. The background circumstances rule plainly contravenes that statutory command by imposing a higher burden on some individuals based solely on their membership in a particular demographic group. This rule is a product of improper judicial lawmaking. The rule was created by D.C. Circuit judges in Parker v. Baltimore and Ohio are company applying their own common sense. These judges determined that extra evidence is required to prove discrimination when a Title VII plaintiff is white. In support of this proposition, the Court cited only its mistaken understanding of the McDonnell-Douglas framework, another judge-made construct. At no point in its development of this new rule did the Court refer to the text of Title VII. The background circumstances rule also highlights how judge-made doctrines can be difficult for courts to apply. Because courts lack an underlying legal authority on which to ground their analysis, There is no principled way to resolve doctrinal ambiguities. The background circumstances rule suffers from this flaw. A number of courts have described the rule as vague and ill-defined. Most notably, the background circumstances rule requires courts to perform the difficult, if not impossible task of deciding whether a particular plaintiff qualifies as a member of the so-called majority. How a court defines the boundaries of a population can affect whether a particular person falls into a majority or minority group. Women, for example, make up the majority in the United States as a whole, but not in some states and counties. Similarly, women make up the majority of employees in certain industries, such as teaching and nursing, but the minority in other industries, such as construction. Defining the majority is even more difficult in the context of race, as racial categories tend to be overbroad and imprecise in many ways. American families have become increasingly multicultural, and attempts to divide us all up into a handful of groups have become only more incoherent with time. And, even if courts could identify all the relevant racial groups and their boundaries, courts would still struggle to determine which racial groups make up a majority. Black employees in Detroit, for example, make up a majority in their city, but not in Michigan or the United States at large. Similar problems arise with religion. As with sex and race, a particular religion could make up the majority or the minority, depending on how the population is defined. And, in the context of religion, the background circumstances rule requires courts to decide both the plaintiff's religion and how the plaintiff's religion compares with the religion of everyone else in the relevant population. Those tasks are formidable, as Americans hold a wide range of religious beliefs, as well as a wide range of views about the proper way to categorize other religions. Americans have different views, for example, on whether Catholics are Christians. The judicial process is singularly ill-equipped to resolve these kinds of faith-based differences. Courts that have adopted the background circumstances rule have offered no guidance on how to decide whether a particular person is a member of the majority. Instead, judges have been left to their own devices to make these challenging determinations. Most courts appear to have sidestepped these difficulties by abandoning the search for neutral principles, and instead assuming that the background circumstances rule applies only to white and male plaintiffs. The 10th Circuit, for example, assumed that the rule applies to white plaintiffs on the ground that white individuals are members of a historically favored group. Similarly, the D.C. Circuit applied the rule to a white plaintiff while acknowledging that whites are in the minority in the District of Columbia. In other words, courts with this rule have enshrined into Title VII's anti-discrimination law an explicitly race-based preference. White plaintiffs must prove the existence of background circumstances, while non-white plaintiffs need not do so. Such a rule is undoubtedly contrary to Title VII, and likely violates the Constitution, under which there can be no such thing as either a creditor or a debtor race. Thankfully, today's decision obviates the need for courts to engage in the sordid business of divvying us up by race or any other protected trait. I simply observe that the background circumstances rule is emblematic of the serious challenges that can arise when judges invent textual requirements. For too long, that rule put a deep scratch across the surface of Title VII. I am pleased that the court rejects it in full today. This case involves a second judge-made rule. Relying on circuit precedent, the 6th Circuit applied the three-step framework developed by this court in McDonnell-Douglas to determine whether Ames's Title VII claim should survive summary judgment. The court today assumes without deciding that the McDonnell-Douglas framework is an appropriate tool for making that determination. But the judge-made McDonnell-Douglas framework has no basis in the text of Title VII. And, as I have previously explained, lower courts' extension of this doctrine into the summary judgment context has caused significant confusion and troubling outcomes on the ground. In an appropriate case, this court should consider whether the McDonnell-Douglas framework is an appropriate tool to evaluate Title VII claims at summary judgment. The McDonnell-Douglas framework is a judge-made evidentiary tool. It was originally developed for courts to use in a bench trial. Its intended purpose was to help bring the litigants and the court expeditiously and fairly to the ultimate question in a Title VII case, that is, whether the defendant intentionally discriminated against the plaintiff. The framework has 3 steps, which this court has summarized as follows. First, the plaintiff has the burden of proving by the preponderance of the evidence a prima facie case of discrimination. Second, if the plaintiff succeeds in proving the prima facie case, the burden shifts to the defendant to articulate some legitimate, non-discriminatory reason for the employee's rejection. Third, should the defendant carry this burden, the plaintiff must then have an opportunity to prove by a preponderance of the evidence that the legitimate reasons offered by the defendant were not its true reasons, but were a pretext for discrimination. The McDonnell-Douglas framework was made out of whole cloth. Its contours have no basis in the text of Title VII or any other source of law. And, as far as I can tell, this court has never attempted to justify it on textual grounds. The McDonnell-Douglas framework exemplifies how judge-made doctrines can have amorphous bounds. Although originally designed for the bench trial context, the McDonnell-Douglas framework has over the years taken on a life of its own. It is today the presumptive means of resolving Title VII cases at summary judgment. And that development has come without this court ever considering, much less holding, that the framework is an appropriate tool for the summary judgment task. Far from extending the framework to new contexts, this court has taken steps to limit the relevancy and applicability of the McDonnell-Douglas framework. For example, this court has held that McDonnell-Douglas is inapplicable when the plaintiff relies on direct evidence to prove his claim. The court has also held that the framework does not apply in Title VII mixed motive cases. We have said that the framework is inapplicable at the pleading stage, and in deciding post-trial motions. This court has further explained that a plaintiff need not satisfy the first step of the framework at trial. And we have strongly suggested that the framework should not be referenced in jury instructions because it is too confusing. Notwithstanding this court's steps to limit McDonnell-Douglas, it is now the framework that courts typically apply to determine whether the plaintiff has proffered sufficient evidence to survive summary judgment. The reason for this expansion is unclear. This court has only once addressed the application of McDonnell-Douglas to Title VII cases at summary judgment, and it held that the framework did not apply. But, however we got here, McDonnell-Douglas now undeniably plays a prominent role in Title VII cases at summary judgment. I seriously doubt that the McDonnell-Douglas framework is a suitable tool for evaluating Title VII claims at summary judgment. In my view, the framework is incompatible with the summary judgment standard. It fails to encompass the various ways in which a plaintiff could prove his claim. It requires courts to maintain artificial distinctions between direct and circumstantial evidence, and it has created outsized judicial confusion. My first concern is that the McDonnell-Douglas framework is incompatible with the summary judgment standard set forth in Federal Rule of Civil Procedure 56. Rule 56A requires a court to grant summary judgment when the movement establishes that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. But the language this court has used to describe the McDonnell-Douglas framework does not neatly track that rule. Namely, the framework does not speak in terms of genuine disputes regarding the facts. Instead, it speaks in terms of proving facts by the preponderance of the evidence. That difference is significant because a plaintiff need not establish or prove any elements, by a preponderance or otherwise, to survive summary judgment. In my view, requiring a plaintiff to satisfy the McDonnell-Douglas framework, as this court has described it, requires a plaintiff to prove too much at summary judgment. If courts are to apply McDonnell-Douglas at summary judgment, they must modify the framework to match the applicable legal standard. For example, at the third step, the question for the court cannot be whether the plaintiff has proved by a preponderance of the evidence that the legitimate reasons offered by the defendant were a pretext for discrimination. Instead, the plaintiff need only present sufficient evidence to create a genuine dispute as to whether the employer's stated reason was pretextual. A second problem with the McDonnell-Douglas framework is that it fails to capture all the ways in which a plaintiff can prove a Title VII claim. McDonnell-Douglas sets forth criteria that, if satisfied, will allow a plaintiff to prove a Title VII violation. But, satisfying McDonnell-Douglas is not the only way to prevail under Title VII. For example, the text of Title VII provides that an unlawful employment practice is established when the complaining party demonstrates that race, color, religion, sex, or national origin was a motivating factor for any employment practice, even though other factors also motivated the practice. In other words, a plaintiff may establish a Title VII violation by proving that an employer took an employment action in part because of an unlawful motive. Yet, the McDonnell-Douglas framework requires a plaintiff to prove that the legitimate reasons offered by the defendant were not its true reasons, but were a pretext for discrimination. That requirement demands more than the text of Title VII. Under the statute, a plaintiff need not establish that the employer's stated reason for its action was wholly pretextual. A plaintiff could prevail even if the employer's stated reason was part of the reason for the employer's action. It follows that a plaintiff's inability to satisfy McDonnell-Douglas's third step does not necessarily mean that the plaintiff's claim should fail. In view of that problem, this court has held that the McDonnell-Douglas framework should not be used in cases where the plaintiff argues that the employer operated with mixed motives. Instead, the framework appears to be limited to cases where the plaintiff argues that discrimination was the sole factor influencing the employer's decision. But, nothing in the text of Title VII indicates that Congress intended courts to maintain this dichotomy. And, even in so-called single-motive cases, McDonnell-Douglas fails to capture all the ways in which a plaintiff could prevail. A plaintiff who cannot establish a prima facie case at the first step or pretext at the third step can still prevail under Title VII so long as his evidence raises a reasonable inference of unlawful discrimination. The ultimate question is simply whether the defendant intentionally discriminated against the plaintiff. Another problem with the McDonnell-Douglas framework is that it requires courts to draw and maintain an artificial distinction between direct and circumstantial evidence. This court has held that the McDonnell-Douglas test is inapplicable where the plaintiff presents direct evidence of discrimination. Our precedent therefore requires courts to make the often subtle and difficult distinction between direct and indirect or circumstantial evidence. In most civil litigation contexts, courts have no occasion to distinguish between direct and circumstantial evidence. In any lawsuit, the plaintiff may prove his case by direct or circumstantial evidence, or some combination thereof. And the law makes no distinction regarding the weight or value assigned to either kind of evidence. The reason for treating circumstantial and direct evidence alike is both clear and deep-rooted. Circumstantial evidence is not only sufficient, but may also be more certain, satisfying and persuasive than direct evidence. That conventional rule of civil litigation, that a plaintiff can proceed with direct or circumstantial evidence, applies with full force to Title VII cases. Yet, McDonnell-Douglas requires courts to determine at the outset the nature of the evidence before it, which often prolongs litigation instead of streamlining it. Because a Title VII plaintiff can prove his claim with either direct or circumstantial evidence, I am skeptical of a framework that requires courts to perform the difficult task of characterizing each piece of evidence. That the McDonnell-Douglas framework has befuddled courts since its inception is yet another reason to question it. 6 years after this court created the framework, the First Circuit observed that the subtleties of McDonnell-Douglas are confusing and have caused considerable difficulty for judges of all levels. That early confusion never dissipated. A decade later, Justice Kennedy made the same observation, explaining that lower courts long have had difficulty applying McDonnell-Douglas. About 20 years after that, Judge Timkovich too observed that lower courts have struggled to implement the burden-shifting framework for over 30 years. The McDonnell-Douglas framework has been on the books for over 50 years now, and courts still report continuing confusion. That those who have carefully grappled with the framework for decades cannot make sense of it suggests that the framework is unworkable. This case did not present the question whether the McDonnell-Douglas framework is an appropriate tool for evaluating Title VII claims at summary judgment. In a case where that issue is squarely before us, I would consider whether the framework should be used for that purpose. In the meantime, litigants and lower courts are free to proceed without the McDonnell-Douglas framework. This court has never required anyone to use it, and district courts are well equipped to resolve summary judgment motions without it. Every day, and in almost every context except the Title VII context, district courts across the country resolve summary judgment motions by applying the straightforward text of Rule 56. In my view, it might behoove courts and litigants to take that same approach in Title VII cases. A textual, judge-created legal rules have a tendency to generate complexity, confusion, and erroneous results. I am pleased that the court correctly rejects the atextual background circumstances rule today. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.